In wake of Independence Day, a day or holiday that was brought about due to the founding fathers of this nation invoking the right of revolution to repel those associated with the British Empire in the year of 1775. I must respond to this particular comment that you made here on NewsBreak. What I cannot understand is how so many civilians in this country who have celebrated Independence Day on the 4th of July for over 200 years has no idea how Independence Day truly came about. Many of you, specifically the one whom I am responding to, believe that the act of so-called gun violence can be curbed through restricting one's access to arms through the unconstitutional act of gun control. And yes, I say unconstitutional act because when you look at the Second Amendment to the Bill of Rights, it specifically states, and I quote, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." End quote. Put another way, we as individuals here in America have a right to take up arms, formulate militias, and eliminate anyone who becomes a threat to our safety and security in order to protect the freedoms of each and every resident who resides in every state that makes up this nation. With that being said, what people ignore, in the words of Andrew P. Napolitano, in his book called "It is Dangerous to Be Right When the Government is Wrong: The Case for Personal Freedom," written in the year of 2011. And on page 121 of this specific book, Mr. Napolitano said, "The government ignores that our right to keep and bear arms is a natural or fundamental right. Many of you civilians, after being indoctrinated by those in civil service for as long as you have, tend to believe that we as individuals should not be permitted to possess arms which are required to the safety and security of each and every person within this nation and elsewhere. That is why law enforcement personnel and military personnel carry arms upon their person, because to talk about it, to restrict their access to arms, is not going to keep anyone in this country or elsewhere safe. What people acknowledge through respect or fear are those who are in an adequate position to compel whatever attacks that they bring forth with equal force. Now, they say that firearms are the great equalizer. I, from personal experience, must agree. Now, because the right to arms is considered a fundamental right, which was made evident in the case of McDonald versus City of Chicago, when the justices of that specific case stated, and I quote, "The right to keep and bear arms was considered no less fundamental by those who drafted and ratified the Bill of Rights," end quote. From that statement, it is clear that we as individuals, in spite of what many of you civilians have been misled to believe by those in civil service, have a right to keep and bear arms under the Second Amendment to the Bill of Rights. Now, what many of you have forgotten or just simply have become too ignorant to understand is that when the Second Amendment specifically states keep and bear, those two specific words have two distinct meanings. First, the definition of bear is, according to the Merriam-Webster's Collegiate Dictionary, 10th edition, to carry and possess arms. To carry and possess arms is the definition of bear as depicted under the Second Amendment to the Bill of Rights. So, clearly, everyone here in America has a right to openly carry the firearms that we own because we have a legal right to own arms. And arms is anything dealing with war. It doesn't necessarily just mean firearms. It means grenades, missiles, knives, swords, body armor, anything that we can utilize in battle, which may become war. Secondly, the term keep as defined in the Merriam-Webster's Collegiate Dictionary 10th edition is, and I quote, to refrain from revealing, end quote. That means that under the Second Amendment to the Bill of Rights, when it says keep, that we also, in addition to carrying our weapons publicly or openly, have a right to conceal them. Therefore, there is no need for any concealed handgun permits. We don't need the permission of other people, to include yourself, to exercise freedoms that have been obtained through blood, sweat, and tears, which is the very purpose for us celebrating Independence Day this 4th of July. Many people have forgotten the meaning behind Independence Day. Independence Day is, in essence, a celebration of our Second Amendment liberty to keep and bear arms under the Second Amendment to the Bill of Rights. We are celebrating that specific freedom on this specific day. And for those of you who are unfamiliar with who I am, you should know that I've studied law for over 2 decades. And there are certain things about law that many people have not been made aware of. So I'm going to go back to the Second Amendment where it specifically states that, and I quote, the right of the people to keep and bear arms shall not be infringed, end quote. Now, to understand that passage more clearly, I am going to direct your attention to the definition of infringed as defined in the Merriam-Webster's Collegiate Dictionary on page 599 to the 10th edition to be exact. And the definition of infringed is, and I quote, to encroach upon in a way that violates law or the rights of another, end quote. So, when you speak about restricting our access to arms through gun control, you are, and those who think as you do, in violation of the supreme law of the land. And we all know that the Declaration of Independence, Bill of Rights, Constitution for the United States of America, to include the Universal Declaration of Human Rights, are considered the supreme law of the land under Article 6 to the Federal Constitution. So you all are in violation of the supreme law of the land. And to be quite frank with you, you are in essence the criminals. Because when you encroach upon the very civil liberties that we have, you are in breach of the supreme law of the land, which makes you a criminal, i.e., felon. And those of us who invoke our freedoms protected by the supreme law of the land are, in essence, law-abiding citizens. That is something that many of you need to get through your thick skulls. Just because you have not been prosecuted for violating the supreme law of the land when you impede upon our freedom to keep and bear arms for our own personal protection and the protection of others does not mean that you are not a freaking criminal. Now, the fact of the matter is, I know the importance of having firearms on your person for personal protection because I, a few years back, was shot without provocation by an unknown assailant while outside of my mother's former residence. The only thing that kept that individual at bay was the fact that I had a firearm of my own that I utilized to protect myself and my mother from the further assault that was perpetrated against me by this unknown assailant. So when people like you claim that the act of so-called gun violence can be curbed through the restriction of our access to arms through gun control are totally insane. You all make no sense. If we took firearms from law enforcement and military personnel, how safe do you think you all who believe in gun control will be in this country? So stop making it appear that we have to have a specific title in this country to exercise certain freedoms that everyone has an obligation to protect and defend, to acknowledge through respect. And for those of you who think that the act of gun control is constitutional, I must say that you are sadly mistaken. Because when you look at the case of United States versus Cruikshank, written in the year of 1876 by the Justices for the Supreme Court of the United States of America, where Chief Justice Waite said on page 553 that, and I quote, "The Second Amendment declares that it shall not be infringed. But this, as has been seen, means no more than that it shall not be infringed by Congress. This is not a right granted by the Constitution. Neither is it in any manner dependent upon that instrument for its existence. This is one of the amendments that has no other effect than to restrict the powers of the national government," end quote. Now, when we talk about the national government, we are talking about members of the United States Congress, the federal court judiciary, which consists of the Supreme Court judges for the United States and the circuit court judges to include the district court judges. It is talking about the president for the United States of America, the attorney general for the United States of America, any civil servant employed within any governmental institution here in America does not, according to this specific judicial opinion, have any authority under the Constitution to make any laws restricting our access to firearms through gun control. That case is very specific because if members of Congress, to include the president and other judges, have no authority to encroach upon our Second Amendment liberty to keep and bear arms under the Bill of Rights, that means that they had no authority under the Constitution to make any laws related to gun control, which means that every law restricting our access as civilians to arms through gun control is unconstitutional. For those of you who are unaware or unfamiliar with the term unconstitutional, it simply means unlawful or illegal, since those are two terms that many of you are more associated with in your daily speak. And I recall that I told you all earlier that the right to keep and bear arms is a natural or fundamental right. Now, you all have to understand that if the right to keep and bear arms is a natural or fundamental right that has been acknowledged by the judiciary within the national court, i.e., the Supreme Court for the United States of America, according to them, who have written opinions on our behalf as the constituency of this country, the right to keep and bear arms, because it is a fundamental right, cannot be encroached upon because it cannot be put up to a vote in any respect, whether that vote comes from a legislative party, the president, the governor, or some judges. And to substantiate that, I'm going to direct your attention to the case of West Virginia State Board of Education versus Barnett. On page 638 to this specific judicial precedent written in the year of 1943 by the Justices for the Supreme Court of the United States. The judges in that case said, and I quote, "The very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, a free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections." End quote. Now, what happens when a bill is put up on the floor before it becomes law during a legislative session? It is put up to a vote. The bill is put on the floor, put up to a vote to determine if it should be a law of a state or a law of the entire nation. What does this specific judicial precedent say about fundamental rights? It says that fundamental rights may not be submitted to a vote, right? Because fundamental rights depend on the outcome of no elections. So, with that being said, because it has been made clear and evident that the right to keep and bear arms under the Second Amendment is a fundamental right, this specific decision also supports the act of gun control being unconstitutional, because without gun control bills being put up to a vote in a legislative body, they would never have been made law. Hence, every law restricting our access to arms through gun control is unconstitutional. But it doesn't end there. In further support of that, the judges of the Supreme Court in the case of Lucas versus 44th General Assembly of the state of Colorado said on pages 736 through 37 that, and I quote, "A citizen's constitutional rights can hardly be infringed simply because a majority of the people choose that it be." end quote. Now, a majority of you civilians, as made evident through the various comments to this specific post, believe that we or certain members of society should not be permitted to exercise our Second Amendment liberty to keep and bear arms under the Bill of Rights. But according to this specific judicial precedent, that specific right, which is also known and has been dubbed a constitutional right, cannot be infringed just because the majority of you civilians choose that it be. You see, from this particular judicial precedent, your view on my right to keep and bear arms is irrelevant because it is my right. And because it is my right, I have a choice to invoke it or not. That choice does not derive on how you feel about me or anyone else for that matter exercising their Second Amendment liberty to keep and bear arms under the Bill of Rights. There are so many judicial precedents that supports the act of gun control being unconstitutional that many of you are unaware of because those in civil service choose to ignore these specific judicial opinions, because to ignore them enables them to benefit at our expense their political, personal, business, financial, and oftentimes spiritual interests or agendas. That is why I have taken it upon myself to view this as my responsibility and duty as a man who has studied law for as long as I have to bring forth this information to you all. And I'm not just speaking about it, I'm actually quoting from judicial decisions what the judges specifically said verbatim about the issue in question here. And when I went back to the Supreme Court precedent, if y'all recall, United States versus Cruikshank, Chief Justice Waite, in right for the majority of the judges who resided over that case, stated that the right to keep and bear arms predated the Constitution for the United States of America. And because that right predated the Constitution for the United States of America, and those within governmental positions only have the privileged authority that we have given them under the Constitution, that is another reason why the judges have declared in our behalf that those in civil service have no authority under the Constitution to restrict our access to arms through gun control. And one of the decisions that I found through my extensive studies of law was the case of United States versus Urquidez, my bad. United States versus Urquidez. On page 288 to this specific judicial precedent that was written in the year of 1990, the Tribunal of the Supreme Court for the United States said, and I quote, "The framers of the Bill of Rights designed the Bill of Rights to prohibit our government from infringing rights and liberties presumed to be pre-existing," end quote. In District of Columbia versus Heller, on page 592 to that specific judicial precedent, the judges of the Supreme Court stated, and I quote, "The Second Amendment codified a pre-existing right," end quote. Now, if the Second Amendment codified a pre-existing right, and those within governmental positions having no authority under the Constitution to infringe upon rights and liberties presumed to be pre-existing, that specifically entails through these two or those two judicial opinions that every act of gun control is unconstitutional. We as people do not have to keep going through this tug of war on the issue of whether gun control is illegal or not, because it is plain and simple to understand that to restrict our access to arms through gun control is an illegal action. That we, for those of you who are wondering, do not even have to acknowledge. We don't have to agree or accept laws that are unconstitutional. We don't have to obey them. And many of you may be wondering, well, if you don't obey a law, when you will be penalized. Well, that's not what the judges in the Supreme Court for the United States of America has said. Now, when I said earlier that we are not obligated to obey any act of gun control because all gun control laws are unconstitutional, as made evident by the various legal authority that I cited to you all in this particular video before, I turn your attention to the case of Robinson versus Baldwin out of the Supreme Court for the United States of America. This particular decision was written in the year of 1897. And on page 297 to this specific judicial opinion, the judges of the Supreme Court said, and I quote, "No court is bound to enforce, nor is anyone legally bound to obey an act of Congress inconsistent with the Constitution," end quote. Now, members of Congress have no authority to enact firearm legislation which disarms we, the people, as made evident in the case of United States versus Cruikshank. That means that we are not bound to obey that law. And that goes for everyone, whether you have a prior criminal history or not. Because, the Bill of Rights applies to everyone. Doesn't matter if you have had a criminal conviction or not. It doesn't matter if the offense of conviction was violent or non-violent. And that's made evident in the case of United States versus Whitmire, written in the year of 1979 by the judges of the United States Court of Appeals for the Fifth Circuit. On page 1319 to that specific decision, the judges wrote, and I quote, "The essence of the Bill of Rights is the protection even of wrongdoers," end quote. Now, we all know that the Second Amendment is up under the Bill of Rights. We know that it is not a constitutional right, as made evident in the Cruikshank decision. So because that right is reserved respectively for the people, as made evident under Amendments 9 and 10 to the Bill of Rights, that means, according to this specific case in the Whitmire decision, that even those with prior criminal convictions have a right to keep and bear arms in spite of their prior criminal history. And many of you may be wondering, well, that's in the Fifth Circuit Court of Appeals, so it doesn't apply to every other state. Because in your view, the judges have no jurisdiction over other states. Well, in that case, I'm going to turn your attention to the case of Bell versus Maryland, written by the Tribunal of the Supreme Court for the United States of America. A court that we all know applies to everyone in every state that makes up this particular nation. On page 328 to that specific judicial precedent, Associate Justice Black stated, and I quote, The worst citizen, no less than the best, is entitled to equal protection of the laws of his state and of his nation. End quote. Now, we all know that the Second Amendment to the Bill of Rights is a national law, right? It's a national law. It applies to everyone within every country that makes up the United States of America. And every law that is passed must be in conformity with the Second Amendment. And I can tell you all that many laws, to include portions of a state constitution, does not comply with the Second Amendment to the Bill of Rights to the extent that they should, because many of these state constitutions have a extra clause in there, which basically entails that those within the legislative branch can make laws that restrict our access to arms under certain circumstances. But that's not what the Second Amendment to the Bill of Rights says. That's not what judicial precedent indicates. But judges believe that because in the Cruikshank decision that I made reference to earlier, even though the judges at that time stated that members of Congress had no authority to make firearm legislation, the judges, after making that statement, did say that state legislators, in so many words, are the only people who had the authority to restrict citizens' access to firearms through gun control. And the reasoning behind that, albeit preposterous, was that the judges in that time were under the erroneous presumption that the Bill of Rights did not apply to those within the state governments, which is kind of odd, being that the Constitution for the United States of America was ratified by members of the state government. So if they ratified the Constitution for the United States of America to include the Bill of Rights, then surely, in spite of what those incompetent bozos in the Supreme Court have said, the Bill of Rights applied to them from the beginning. So I never understood why these dumb judges would make that preposterous comment in their judicial precedent. However, in the case of McDonald versus City of Chicago, the judges in the Supreme Court had a change of heart. And they had a change of heart because in 2010, in the McDonald decision, the judges ultimately came to the realization that they were wrong, or their colleagues were wrong, when they claimed that the Bill of Rights only applied to members of the national government, i.e. Congress, the president, federal court judges. But they had a change of heart in 2010 when they acknowledged that the decision of their colleagues was erroneous by stating that the Bill of Rights, the Second Amendment to the Bill of Rights, to be specific, also applied to the state governments or state governmental bodies, to be specific. Because I hate using the term government because that's too vague. It doesn't necessarily point to the people or person that I'm specifically speaking about. And I think that that is a mistake that many of us have made. But with that being said, it is clear that like members of Congress, so too the state legislators not have the authority under the Constitution. Because like I said, Right to arms predated the Constitution to make laws restricting our access to arms through the act of gun control. So with that being said, you all have to stop clinging to the outlandish belief that more gun control is going to curb criminal activity from being perpetrated against us by lawless individuals or those in civil service who are hell-bent on subjecting us to acts of tyranny. Stop believing that. And if you all believe that, do me a favor and stop calling on law enforcement and military personnel to come to the scene to aid you in your own self-protection if you do not believe in the act of keeping and bearing arms to the extent that the Second Amendment entails that it was enacted for. If you all believe that guns have no place in American society, then perhaps we should take guns from all law enforcement and military personnel. And if we were to do that, do you think people will come to your aid when you're being attacked by a known or unknown assailant? You think people are really going to risk their lives to come to your aid when they do not have adequate protection to ensure their safety when they come to your aid? To ensure that when they come to your aid, that they have confidence that they can come out of the situation unscathed to where they can go back to their family and friends. You all have to freaking think and stop allowing your emotions to cloud your better judgment when it comes to the issue of freaking gun control. Because I'm going to tell you all something. You all do not speak for me. And when I say you all, I'm talking about civilian and civil servant alike. I'm the one who got shot by an unknown assailant. But if you all were to ask me right now, here, today, if the individual who shot me still has the right to keep and bear arms under the Second Amendment, the answer to that question from me to you is freaking yeah. The right specifically says it shall not be infringed. So it doesn't matter how I feel about the individual based upon what he has done to me. It doesn't matter what I think about the individual based upon what he has done to me. The fact of the matter remains that the Second Amendment to the Bill of Rights specifically says that that specific freedom shall not be infringed. And I have to stand on that. Because if I do not stand on that, I will open up the doors for the rights that I cherish to be violated and ignored also. And that is why so many of you have found yourselves in these positions here in society that you have found yourselves in today. You all are the cause of all of this so-called gun violence. Because you all are so hell-bent, based upon your personal feelings, to restrict people's access to firearms. So I'm going to go ahead and blame you and people who think as you do. And there's a lot of people out here in American society who are unfamiliar with the true laws of America. Because I'm willing to bet that many of you didn't even know about the judicial decisions that I made reference to in this video today. Heck, I didn't know about a lot of these particular judicial precedents until about 8 years ago. And that's like 10 years into my studies of law. But I'm here to try to educate you all because I know, in spite of what you believe, what it takes to keep us safe in the society that we live in. And I'm going to tell you all something. Praying to God, praying to Jesus, it's not going to cut it. Because Jesus, through God, has given us free will. Jesus acknowledges the fact through God that we have free will. That's a better way to say it. So if we have free will, there is no way that Jesus Christ nor God is going to come down here in the flesh and stop someone from doing something to you because you asked them to, knowing that we all have free will. And like my pastor said many years ago in a sermon that he held after speaking to me about this very issue, God created us with common sense, y'all. And with that common sense, Pastor Grant said that he sleeps with a Bible in one hand and a gun in the other. Because common sense tells us that God made a way for us to protect ourselves from those who are hell-bent on harming us. And when they harm us, they harm the temple of God because we are the temple of God, because the Spirit of God resides within us. So it's up to us to protect the temple, to protect ourselves, to protect God's people, our people. And if we don't have the adequate means or resources to do that with, we cannot expect nothing different but for us to undergo unwarranted trials and tribulations in a society full of wicked people. So no, the answer to curbing acts of so-called gun violence is not to restrict one's access to firearms. It is to encourage the invocation of the Second Amendment to the Bill of Rights to keep and bear arms everywhere we go, because we do not know when someone hell-bent on harming us will strike. We do not know where they will strike, but we do know through using common sense and logic based upon what has transpired throughout the history of this country, or the world for that matter, that people can strike anywhere at any time. So we have to be prepared, people. But if you don't want to be prepared to protect yourself, do not attempt to force your incompetent beliefs upon me and those like me who believe in invoking their right to keep and bear arms under the Second Amendment.